Good morning, everyone. Thank you so much for logging on to join us. Hopefully, you are having some dry skies as we are here in Grand Rapids. I'm seeing people signing in from all over the state, so welcome and thank you. This is the Fair Housing Deep Dive for senior housing providers. We are very excited to offer this training, which is being recorded thanks to a very generous grant from MISTA, the Michigan State Housing Development Authority. I'm Liz Keegan. I'm the Director of Education and Outreach at the Fair Housing Center of West Michigan. Joining me to co-present this morning is Bree Miranda, one of our Education and Outreach coordinators, and Lindsay Owens is keeping us running behind the scenes. Our contact information is here. You should have it already. Hopefully you received also an email with lots of handouts late yesterday. So if you didn't find that in your email, check your junk or clutter. And if you aren't finding it, please put your email in the chat with a request for the handouts, and we will make sure to send those to you. Please make sure to follow us on Facebook. We're also on LinkedIn. We are always sharing good information there, and we welcome you to follow along. There's lots happening in fair housing these days. A little bit of housekeeping before we start. We are taking attendance using a separate evaluation link, which will be provided towards the end of the class this morning. Each individual must fully complete the evaluation by the end of the day tomorrow, May 23rd by 5 p.m. Please make sure you're putting in your full name, a complete mailing address, things like that, so that we can get certificates out to you. But it's very important that you each complete that survey. It should show up in your browser after the webinar ends if you're logged on. If you're watching as a group, you'll need to make sure you all share that link. We cannot see you or hear you. Please use the chat to communicate with us if you need to. If you have questions, please do use the Q&A feature and not the chat because sometimes we lose questions in the chat. It's easier for us to track questions, which we love to get using the Q&A. We'll also save time for questions at the end, and you're welcome to email specific situations to us, especially if there's a lot of details and we can't review it fairly quickly. Please do follow up with us.
I do want to
As I mentioned,
note, sorry, Liz, sorry to interrupt. For the evaluation and for the attendance or verification, please put the correct address. Please make sure that it's the address maybe to your office rather than your personal address, as
Mhm.
we've had a lot of folks be reaching out, not getting their certificates, and it actually went to a personal address and the company wants it. So please check with your
Ah,
company too to see
yeah.
where best that certificate should go, as we can't always and quickly get those to you as we have a lot of other trainings going on.
Yes, yes, we had a really great response for this class too. So we're thankful for you all making the time to sign on this morning to think about senior housing and fair housing, which we acknowledge is a very complicated area. There's lots of housing options for seniors, and therefore there's more fair housing to consider. So we're really grateful for you making the time, and we want to help you document that you attended the training here with us today. As I mentioned, it will be recorded and made available. So we'll share that link as we always do after the class. I think that's it for housekeeping. We want to dive in and hear a little bit from all of you. So I am going to launch a quick question, a poll here. We're curious to hear from all of you. What is your level of fair housing experience? Would you rate yourself as new, more in the middle of having some fair housing knowledge, or on the end of the spectrum with a 5 that you feel you know a lot about fair housing? And I suspect we have a pretty experienced group because I'm recognizing some of the names, but I know there's some of you who are new, so welcome. We'll give about 30 more seconds here. And we'll take some polls throughout the class. They're anonymous. They're really just used for engagement. So I encourage you to participate, but want to let you know that they're not required or anything and that they are anonymous. Okay, about 10 more seconds here. Okay, share the results. So as I suspected, we have a pretty experienced group, which is great. A handful of you are new or feel that you have some fair housing knowledge, but a lot of you are on the more experienced side of things. So I encourage you to participate and let us know your thoughts. If you have best practices, questions that you want to share, please feel free to do that. We'd love to hear from all of you. All right, one other, going to get us started thinking about some of the details here. Another quick question. Do you know if your property has any federal funding? It's okay if you don't know this. This is a possible homework question, especially for those of you who might be new. We ask because having federal funding triggers additional regulations and additional law. So if you're not sure, we do encourage that you speak with your team and make sure you know whether or not you have any federal funding, because that can trigger additional fair housing responsibilities. And I suspect we have quite a few folks who do have federal funding. Seeing some yeses in the chat. And again, if you don't know, that's okay. It's just something that you'll want to follow up on. We'll give maybe 10 more seconds here. Okay. So as you can see, 2/3 of you said, yes, we do have federal funding. So we'll be sure to make sure we're calling out the rules and regulations that apply. For those of you who said no, who are offering senior housing on the private market, we still recommend that you look to HUD regulations, HUD guidance, best practices. We pull that from HUD as well. We have state law that also mirrors a lot of the HUD guidance. So even if you don't have federal funding, things are kind of more aligned than they have been in terms of protections that are in place. And one of the things that we always look to is cases and HUD guidance and the standards that HUD holds themselves to as they do oversee enforcement of fair housing as a starting place to help with fair housing compliance. So thanks for sharing that with us. And for those of you who said not sure, again, recommend that you talk to your team and do a little homework there to follow up on that question. So we have an ambitious agenda. We will take a break about an hour in, but we're going to be moving fairly quickly, talking about what fair housing is, what our center does, what's happening in senior housing, and then focusing on some laws and the legal update. We always provide kind of a basic overview of all the fair housing laws. For some of you, that's going to be a review, but we do have new protections in Michigan that we're excited to share, so we'll be talking about those. A big portion of our time will be focusing on disability status. That continues to be our number one allegation brought to our local fair housing center, and that's also been a national trend now for about 15 years where disability-based discrimination is the number one allegation. And of course, there's a correlation with senior housing, so we'll spend a good amount of time on that before we shift to advertising and applications, looking at the use of criminal records, and then gender protections. We'll share resources at the end, and as I mentioned, we'll take questions throughout. Please do use the Q&A feature to submit questions. We'll try to take them if we can as we go along, or circle back to them towards the end of our time together. But we really encourage that you use the Q&A and submit those questions to us. You can do that anonymously should you choose as well. So very briefly, our Fair Housing Center, we're celebrating 45 years this year somehow. Time flies. We're a private nonprofit organization. We don't have any enforcement authority. We work with enforcement agencies to assist people in asserting their fair housing rights and upholding fair housing law. Our mission is very straightforward. All we do is focus on fair housing. We want to prevent it and eliminate it, tackle any illegal housing discrimination, tackle policies, make sure people have access to training. And again, we're really thankful to MISTA for allowing us to offer these regular trainings at no cost online. Just a tremendous opportunity for us to put a lot of fair housing information out. Many of you are attending a lot of the classes, and we just really appreciate that. This is a really tremendous opportunity to get fair housing information out there and help people understand the benefits of inclusive communities. We do not have attorneys on staff, and therefore we cannot give legal advice. That follows, I think. All information that we're sharing today is current to the best of our knowledge, but could change at any time. And just want to let you know that discrimination can be reported anonymously. That includes by housing staff. We do get allegations of housing discrimination from staff, as well as from the community residents, people seeking housing, visitors looking at properties, applicants to housing. Anyone is able to file a fair housing complaint across the different venues where complaints can be brought, one of which is our agency, but people can also file with the Michigan Department of Civil Rights or directly with HUD. They can file in the courts. So it's important to recognize that there's an open door process to bring fair housing complaints and other types of civil rights complaints. So what we do in our trainings is really focus on helping manage fair housing risk. We want to lower anybody being on the receiving end of discriminatory behavior and help housing providers proactively comply with fair housing laws to eliminate discrimination from happening on the front end. That's something that we really seek to do with all of our education, our materials, our best practices, our tools, etc. So all that to say that we don't do anything but fair housing. Here, as you can see, there's some common housing issues. We get a lot of questions about these issues, but we really only focus on fair housing laws, and we'll do our best to send people to the right local agency or resource. So we're always looking to get that referral information out there, but we don't work on building code or maintenance. We don't handle tenant landlord law matters. We don't provide any credit counseling or homebuyer classes. We do a lot of fair housing rights classes in addition to this type of class, which is more of a compliance and fair housing responsibilities focused class. We don't do foreclosure prevention or offer housing, anything like that. We are one of several fair housing centers in the state. These are the traditional fair housing centers. You can see the service area here. Our service area is kind of that teal green, although we do end up doing a lot of education across the state because some of the other fair housing centers don't provide these types of trainings. I do encourage you to get to know your local fair housing centers, so they're all linked here, so that you can make sure you're kept abreast of what's happening in your region of the state. If you don't know who your center is, we're happy to reach out and make those connections for you. But as I mentioned, you've got links to the websites here. But we cover the Upper Peninsula and kind of the northwestern half of the Lower Peninsula there. So in terms of what's happening for housing for older adults, it's not going to surprise anyone that we have a lot of housing shortages, lack of affordable, accessible, attainable housing is a big conversation, and that can impact specialized groups like our older adults. The baby boomer generation is now entering older age, and this is happening, unfortunately, during this historic housing shortage. So it got kind of pressure from both ends. The adult population in the country, those 65 and older, is increasing at historic rates because we are where we are with the boomer generation. By 2040, they estimate there will be about almost 81 million older persons. And that's coming up a lot faster than I'd like to admit. And this growth is being observed across all communities. Urban, suburban, and rural areas across the country are all reporting increases in older residents. And that's happening here in Michigan. The population that is growing in Michigan, I saw in 2019 was older adults. That was the only population that showed growth here in Michigan, based on a report that MISHTA did. So this is also a time when we're seeing during this decade, the first baby boomers will start turning age 80. So this is really accelerating the rate of growth among those in our oldest age groups. I also want to acknowledge that, as you all know, working in senior housing and offering senior housing, that it's a very complicated area. There's different levels of and many different types of housing, different styles of programs. It can be set up differently to offer services. There's also independent living, which offers no additional services. And there's kind of this spectrum, right, that changes across offering levels of different care and supervision. Of course, cost is always an issue that we really want to be aware of. A lot of older adults are already thinking about where they want to age in place and where they can afford to live for the rest of their lives. This is a huge decision. And so it's really important that fair housing choice is upheld during this really monumental decision of where can I spend the rest of my life? What can I afford to do? What do I want to do? Where would be best for me? So many big questions to be answered. So we really want to make sure that we're upholding fair housing choice across this entire spectrum. Older adults should be allowed to choose from what is available. They should be allowed to inform their senior housing providers about their needs and what works best for them. So we encourage kind of that listening ear as always the first approach is listen to them, ask open-end questions, let them inform you of what they need, and then start working backwards from there. They also should be free from any assumptions being made about what they would want or need or like. And a lot of people I know who work in senior housing are so passionate about working with this population, love working with this population. And so there's a lot of care and concern that goes into it. But we have to be very careful to make sure that our care and concern does not unintentionally remove rights away from older adults. So it's really about striking that balance. In terms of what's happening in the laws and a legal update, fair housing laws are all about prohibiting discrimination based on protected classes. There's layers of law. There's federal law, state law, and local fair housing laws. So if you're ever not sure about what laws apply based on where you operate or what type of housing you're working with, feel free to reach out to us. But it's really important that you get to know what your protected classes are based on where you're working. It's a really way to keep fair housing in the front of your mind when you know who is protected, and you want to be really careful that you're not treating anybody differently based on them being a member of that protected class. Fair housing laws cover transactions, sales, home loans, homeowners insurance, and even covers zoning and land use. There's also protections that occur for people after they have moved in. So a lot of fair housing is about access to getting that housing that they need, but there are protections that exist for post-housing, post-move-in once they've acquired the housing. And where we live directly impacts how we live and what resources we have access to. So really being able to choose without experiencing discrimination is critical. Housing is going to be covered, especially in Michigan. The Fair Housing Act applies to what they call dwellings, which can even be vacant land that's available for sale or lease, properties that are being built during the design phase, existing properties that have been around for a long time, really any sort of building structure or even a portion thereof that's intended as a residence is likely going to be covered by fair housing laws. So I do hear this on occasion from senior housing providers that people were told fair housing laws don't apply to them, or they were trained to, ignore fair housing because there was a that is not true. Fair housing laws cover senior housing among all of these other areas and housing professional roles, condos, HOAs. This includes senior communities, rentals, residences, transitional housing, subsidized housing, run by housing commission, banks and lending institutions, senior housing, all covered by fair housing laws. So this is inclusive of independent living communities and programs, nursing homes, assisted living, rehab facilities, residential care facilities, continuing care retirement communities, skilled nursing. These have all been found to meet the legal definition of a dwelling and therefore are likely covered by fair housing laws. So it's best to assume that fair housing applies. If you have doubts, we can point you into the direction of what research you can do. Best practice, assume fair housing is going to apply when there's a transaction of offering housing in exchange for dollars, or the program is designed to house people. It's all about the protected classes. Once you know your dwelling is covered, it's safe to assume that it is. So who is protected? The list is growing. So even if you've been through training, if you haven't been trained since April, we have some new laws that we're going to talk about. But across the country, it's race, color, national origin, sex, religion, disability status, familial status, meaning presence of a child under the age of 18 in the home. Those of you with federal funding are subject to the access rule put out discrimination on marital status, sexual orientation, and gender identity. It kind of expands the definition of who can comprise a family. Michigan laws now mirror those protections fully now. So it is state law. So best to assume that these are protections that apply, even regardless of what kind of funding you have. You're going to be covered by Michigan laws, which also have age protections in addition to marital status. In race, we have an expanded definition that's inclusive of hairstyle And then sexual orientation, gender identity, or expression was added last year. And then source of income and rental housing was added in April of this year. So we will circle back to that and spend a little bit more time on that in a moment. But the local protections can vary. So that's homework that you'll need to do. As I mentioned in 2024, the state law was amended to add sexual orientation, which is heterosexuality, homosexuality, or bisexuality, having a history of such an orientation, and also then gender identity or expression was added. So this is having or being perceived as having a gender-related self-identity or expression, whether it's associated with someone's assigned sex at birth or not. So that's how the state law defines those two protected classes. And then in April, both our state civil rights law and our tenant landlord act were amended to prohibit discrimination rental transactions on the basis of source of income. This is now in effect as of April 2nd. So it's any sort of benefit or subsidy program that issues housing assistance like housing choice vouchers, they used to be called Section 8, any public assistance or veterans benefit dollars, Social Security, SSI, disability income, retirement, or any other programs issuing housing assistance coming from federal, state, local, or nonprofit entities. So a very broad definition of income that goes well beyond employment-based income. So if you're not sure what your protections are, check your local fair housing center. If you need help, if you're outside of the state of Michigan, we can help you with that. But here's a couple of code libraries where you can look up different cities, villages, townships. But right off the bat, I'll tell you Ann Arbor, Detroit, Grand Rapids, Holland, Jackson, Kalamazoo, Kentwood, Lansing, Traverse, Wyoming, all have local fair housing ordinances. And you can find a lot of those in West Michigan on our web. To file, not to file within a 2-year window. The administrative processes are HUD and Michigan Department of Civil Rights. So that window is a year for HUD to receive a complaint after the date of the violation, 1 year later. And same for the state Department of Civil Rights, that date of the last day the policy was in place or the discrimination occurred, you've got 6 months to file with the Department of Civil Rights. So for best practice and compliance there, you're going to want to keep your records for housing for older persons. There's a narrow set of exemptions here under federal and state law. Exemptions for religious organizations and private clubs are in place. And there's also a specific exemption for familial status provisions that are allowed for qualifying senior housing providers under Housing for Older Persons Act or HOPA. So you saw age was listed as a protected class. If you're wondering how we can have these age limits, this is why. There's a federal law that applies to many different types of housing facilities and communities like condos, co-ops, as I mentioned earlier, homeowners or residents associations, zoned areas covered by local government, leased property, mobile home parks, manufactured housing communities. We do see a lot of older adult communities that are utilizing that type of housing. So it's going to apply. It allows for only 2 age restrictions. Really does need to be offered and run and operated with the intent to house older persons. It's kind of a recognition that sometimes older adults don't want to live with families with children, for example. So senior housing is exempt from federal familial status and state age provisions, meaning if you are compliant with HOPA, you can have these age restrictions and exclude families with children in most cases, but you must meet the criteria for HOPA. So HUD has determined that it's designed for and occupied by elderly persons. That's one standard. It's occupied 100% by people who are 62 or older, or it houses at least one person who's 55 and older in at least 80% of the units, and adheres to a policy that is, again, stating that they are designed to house people who are 55 and older. So those are the only standards to meet that criteria. So again, it's 80% units have somebody at least 55 and older if you're trying to meet that threshold and maintain it. You also have to publish and adhere policies and procedures that show that's how you operate, and you must do routine age verification to make sure you're meeting that threshold. So it can't be just assumed or informal. It has to be documented. As with many things in fair housing, you want to document it. And again, if you have 55 and older property, it should be in advertising, applications, leases, any purchase agreements, in your rules and bylaws, or any other official documents. Okay, so circling back to source of income protections, which we mentioned are brand new here in Michigan and just went into effect in April. The new laws do not include either of the following. Income that a tenant can't show is derived from legal sources and activities, and it must be provided on an ongoing basis. So again, any tenant that is seeking to utilize these protections must demonstrate that the income is legal and it is provided on an ongoing basis. Another caveat that was added is that they want the housing assistance to move fairly quickly. So if it's not provided, or excuse me, not approved by the appropriate agency within 30 days after the landlord submits all the information that's required as part of the approval process, including things like repairs or whatever, the protection drops away. So it needs to be timely and the income needs to be legal and from ongoing sources. Who is covered by these laws? The Michigan laws are going to protect everyone from illegal housing discrimination due to their source of income when they seek to rent or are renting a home. There are certain exemptions, though. The law would exempt landlords who don't own 5 or more units. So it applies only to landlords and affiliated people with 5 or more housing units in Michigan, including units under any of the related entities. So if someone is an owner and operating a separate LLC for their rental business, that would be covered. So landlords of a rental unit or rental property include the owner, the person who leases or subleases to someone, acting kind of as an agent or a manager there, anybody authorized to exercise any aspect of managing the unit, including the people who would accept the income or the payments of rent. So this is the amendments under state civil rights law into the Michigan Tenant Landlord Act. There's a series of prohibited behaviors that I'll just quickly review. Again, these are all prohibited behaviors based on the source of income in rental housing for covered units only. So it would be a violation to deny or terminate someone due to their source of income, make any distinctions, discriminate or restrictions based on source of income in the price, terms, conditions, fees, or privileges related to renting the unit or occupying the unit, or make any distinctions in furnishing any of the facilities or services in connection that come with renting that unit. Other prohibited behaviors, it's a violation to otherwise make unavailable or deny any rental unit to the tenant if the tenant is otherwise eligible, but for their source of income, they meet all of the other criteria, they can afford the unit, they shouldn't be turned away because of where the money comes from. It's a violation to represent to any prospective tenant that a rental unit is not available for inspection, rental, or lease when in fact it really is, or to knowingly fail to bring a listing that is available to a prospective tenant's attention based on their source of income, or refusing to allow them to inspect the unit based on their source of income would also be a violation. Further, to make any distinctions, discriminate, or restrict against tenants in the price, terms, conditions, fees, or privileges related to renting the unit on the basis of the prospective or current tenant's use of emergency rental assistance. So they shouldn't be treated differently from all other applicants. If they require a prospective tenant or a current tenant to have a certain amount of income, they should not exclude any source of income in the form of a rent voucher or a subsidy when calculating the income that the tenant has. This subdivision does not apply to that emergency rental assistance. It's a violation to attempt to discourage the rental or lease of any unit, or to put out any discriminatory notices, communications, ads, signs, anything that would discourage anyone from seeking the rental based on their source of income. That would include people who write the ad, any platforms that publish the ad, anybody who is a part of pushing that communication out could be held in violation of this part of the law. And lastly, it's also protecting people who are in the housing business. You know, you don't have to be forced to violate this section of the law. It's illegal for an employer to coerce a staff person, for example, to violate these protections. And conversely, it also protects people who want to exercise these rights. They should not be subject to coercion, intimidation, or threats because they are trying to utilize these rights as granted by these laws. So this is something that is very new. There's a lot of questions that haven't been answered answered. So we're aware that a lot of this will be decided kind of on a case-by-case basis as cases are brought and case law becomes established, or we hear from the Department of Civil Rights and learn from some of the decisions that may be made as people bring allegations forward. So we also have a lot of questions. There's a new fact sheet that we put together as part of your handouts. So we'll take a look at some of those signs of possible discrimination. Some of these we've already covered, but examples would be refusing to rent to someone because they have Social Security income, charging extra fees or a higher deposit or higher rent because someone is a voucher holder of a housing choice voucher or formerly called Section 8 voucher, telling an applicant with a Veterans Affairs voucher that the unit has rented, even though it is still available, would be a violation. Placing an ad with language that states no Section 8 would be a violation. Not allowing an available unit to be seen or inspected because someone receives alimony, not allowing for equal access to facilities or amenities because of the source of income, and not maintaining the units to an equal standard because they are occupied by voucher holders. Those are all signs of possible source of income discrimination. So some best practices to be considered: providing equal treatment to all applicants and tenants, regardless of their source of income, is always a best practice. Accepting and counting all income derived from lawful ongoing sources. Do not express any limits or preferences about income sources or employment status in any ads or communications, websites, etc. Working with an agency that administers a voucher or any sort of program assistance in a timely manner would be beneficial. Updating your policies and practices if needed to enter into the third-party agreements that are required, or setting up to accept third-party payments may be necessary. And do not retaliate against tenants or applicants who are seeking to utilize or enforce their fair housing rights under these new protections. So some best practices to think about. And again, you've got the laws as part of your handouts and our fact sheet that kind of reviews a lot of this information as well. So real quick, we'll do a poll here to kind of think about how do we apply this part of the new laws. So we're going to ask which of these scenarios would be a fair housing violation under source of income protections. It should be multiple choice, so you can choose any of these three that you think would be violations. Someone with a voucher applying to a 55 and older property, but they are denied due to recent outstanding rent and unpaid damages. A senior voucher holder being charged higher rent because their voucher covers more. Or our last one here, a 67-year-old with a voucher puts in a maintenance request and doesn't hear anything for a month. Their neighbor who doesn't have a voucher had a similar issue and had it fixed within a week. So we'll give you a little bit of time to make your choices. I will give another minute here. I know there's a lot to consider, and these are new. Okay, about 15 more seconds. And again, the polls are optional just to help us start apply and think about source of income and the other questions that we'll be asking this morning. Hopefully you've had enough coffee, tea, or water, whatever gets you going in the morning to think these through. All right, just about 5 more seconds and then I'll share our results here. And as I briefly mentioned, there's a lot that the law doesn't quite address. We have a lot of questions. We've heard a lot of questions. And what we've basically heard from the state is that a lot of these questions that we have will have to be assessed on a case-by-case basis. And we'll get some clarity through either case law that's established, or maybe they would amend pieces of the law to be revealed. But we do have a lot of questions. A lot of them are good. And so we're all working hard to figure this out together. So it is new. So we're doing a lot of education about this. So hopefully you can see the results here. 78% said the last one is a violation. I agree with that, especially because it's kind of spelled out there in the law. And then a senior voucher holder being charged higher rent because their voucher covers more, that would be a violation as well. The first one, if you have a standard in your screening practices that would prohibit anyone with unpaid damages and back rent being owed as a denial, that would be consistent regardless of their source of income. So the first one I would say is not a violation, but the second and third one are violations. Okay. We're switching gears here and we're turning it over to Bree to talk about disability status protections.
Thanks, Liz, and sorry about that. I lost internet for a second. We do
Oh,
have a
that's
question
fine.
that I wanted to ask. I was going
Oh,
to
great.
try and answer, but it
Okay.
is it depends. But somebody had a question about does fair housing apply to short-term rentals?
Okay. Sorry, you froze for a moment. And that answer is it depends. It depends on the length of the lease. It depends on how long someone can stay there. So we'd need more information. Generally, if it truly is recreational, similar more towards a hotel stay, we would see that maybe as not covered. Americans with Disabilities Act and other public accommodations laws would apply there. But we need more information about kind of the length of the lease and the type of housing before we could answer that one in full detail.
And then somebody was asking a clarifying question about the five units or five property. So that would be for the source of income, and it's 5 units. So even if you have one property and it has 6 units, then you qualify as accepted
Covered.
source of, yeah,
Mhm.
covered.
Yeah, great.
Yeah, so now I
Good.
can get started on disability protections. So, under the Fair Housing Act, it's disability is pretty broadly defined. It is defined as having a physical or mental impairment that limits a major life activity, having a record of such impairment, or being regarded as having such an impairment, even if you don't. So, what is major life activity? It's really anything that really affects your day-to-day life, your physical, mental, social activities, working, so sleeping, walking, bathing, eating, breathing, driving, hearing, and seeing. So anything that could affect your day-to-day life is really considered a major life activity. There are 2 ways that people with disabilities can have equal access and enjoyment to their housing. It's through reasonable accommodations and reasonable modifications, and we'll talk about both. But these 2 documents here linked are really great resources. They kind of are a Q&A type feature that you can look at to answer some of your questions you may have regarding different situations that you may encounter. So for a reasonable accommodation, that is a change in a rule, policy, or procedure that a person with a disability must need or may need to have equal access and enjoyment of their housing. With a person with a disability would have to have a disability and a disability-related need to ask for that accommodation. It's really important to really recognize that it's a request. They may not say, "I have a reasonable accommodation." It may just be like, "Oh, I have really bad hip problems, and so walking far distances is an issue." So that kind of, they didn't really say I have a reasonable accommodation, but there was kind of an ask in there. So it kind of, it requires it's called the interactive process and working with the tenant to see what they need. And then, especially documenting when it's disclosed or requested. And then if you don't know, let the tenant know that you're going to look into it and you'll follow up. Some examples of reasonable accommodations would be allowing an overnight caregiver, even though there is maybe an overnight guest policy, allowing an assistance animal despite a no pets policy, assigning a designated accessible parking space, despite there being a first come, first serve parking policy. This is one we get questions a lot because a lot of folks have the required spots for public accommodations through the Americans with Disabilities Act, the ADA. However, fair housing is separate from that. And so if a person with a disability needs a closer spot to their unit, they have the right to ask for that. So that is separate from those spots you've already lined due to, getting access to your leasing office or things like that. Accepting rent based upon the arrival of disability income without charging late fees. So if somebody receives their disability income on the 6th, but you have rent due on the 1st, and then you accrue fees after that, a person could request that theirs be due on the 6th, and then, the late fee policy would stay the same, but that date just changes. Transferring to a different floor unit because of a disability related need, releasing from a penalty, or sorry, releasing from a lease penalty free if the housing no longer meets the needs. This is kind of a last resort if there's really nothing else that you as a housing provider could provide to them. It just does not work for them. You don't have any other units available, things like that. There's just, this is kind of the last resort for them to be able to have housing that does fit their needs. And then the last one, ensuring effective communication, such as through ASL interpreter if a person that is hard of hearing or deaf needs it. This is a case out of Georgia through a housing authority where a lease was terminated for a tenant with disabilities. He had a medical episode that caused his blood sugar levels to dysregulate, and the property was limited to elderly and people with disabilities, and it did receive federal funding. The tenant had a medical crisis. He was disoriented and confused. He was knocking on several neighbors' doors at 3 a.m., trying to find his phone and his mother's unit, which was a mile away. Two neighbors did call the police. However, there was no arrest or citation or ticket, but they helped him home, and they told the neighbors, were saying, he wasn't harmful. They were just concerned. And he did go to the ER the next day. He then a couple days later, he reached out to the property management or the apartment complex, or sorry, not the housing authority, and explained everything. And they even reviewed the police report. And then there was a termination letter taped to his door. He requested to be allowed to stay as a reasonable accommodation as he was receiving treatment. However, the housing authority did go into litigation, and they did deny his reasonable accommodation and continued with the eviction proceedings, even though he had a doctor provide information on his medical history kind of and his symptoms being managed. And he got different medication, got a medical alert bracelet. So he was managing his disability. And he actually had another medical episode, which was heart related, so he could not appear in court. Eventually, the housing authority did end their litigation, their eviction proceedings, but he did move out because he just was kind of really nervous that they would refile because they reserved that right. He did file a HUD complaint in 2021, and that is still ongoing to this day. This is a case out of Arizona. It was an independent and assisted living center was tested on behalf of somebody named Frank, who was deaf and needed ASL. They offered specific amenities included in his rent, housekeeping, common dining, medication reminders, 24-hour staffing, and safety checks. The granddaughter who was engaging in the conversations for him had said he was be moving to Florida, and that mostly exchanged written communication such as cards. They asked what accommodations would be provided for him, such as medicine reminders. They responded that they would likely use pen and paper since they had no sign language abilities. The manager stated they didn't believe it would be a problem and they would work it out together. They would find a comfort zone for his communication. She expressed a willingness to meet with him to assess his needs and that if he would be a good fit for the community. She stated that she had used lip reading in the past to communicate with deaf individuals. So really, there was no effort in this to see like what does he need. That she never asked exactly what did he need and then respond to that. She gave all these options that she had used previously. Per the policy, staff would call first, then knock on the doors to conduct safety checks, and this included for deaf residents. And then if nobody answered, they would enter the room, which would be every time for a person that was deaf. Staff then stated that Frank would have to pay for himself and install his own auxiliary device, which was a doorbell with a flashing light to let him know that somebody was at the door. They further stated that all residents have a life alert button that they can use, and that she was sure he had a special phone that staff would check on him if he did not come down for a meal. However, they never offered to provide that flashing doorbell. Again, they were making him provide that. However, that is something that he could request, and he did request. And he never was offered the special cell phone or any other alternative auxiliary aids. The safety check was designed for hearing people, and a deaf individual would not hear a knock at the door. If there was an emergency, deaf individuals would not be able to be notified in time. So the property was legally required to provide this doorbell free of charge, and they could not require him to install it because they needed to ensure that he had full and equal access under the ADA as well as the Fair Housing Act. Deaf residents were treated differently or unequally compared to hearing residents because of that knocking on the door. Like that's a big part of the access to the housing. So when thinking of best practices for effective communication, it's really important to refer to your reasonable accommodation policies. We did provide a sample, a handout for that. Additionally, housing providers should be following the lead of the person requesting the the communication. If it's a request for ASL interpretation, it should be evaluated as a reasonable accommodation, even if it's for a tour, completing an application, signing a lease. It's at any part of the process for an individual that is deaf or hard of hearing. And then it's really important for you and your staff to know how to call and arrange for an ASL interpreter when it's requested. If the first option or request doesn't work, there's a lot of delays, there's timing concerns, like you've put in the effort, but it's just not working out. There still has to be an alternative offered, and you have to work with the person requesting it to see, oh, sorry, we weren't able to get one. We put it in, last week and no one's been assigned. What would work next for you? Really that interactive process of working with the tenant and seeing what would work best for them as a person with a disability. However, there are some things that you can ask yourselves and consider when processing reasonable accommodations, and there are things that we can help with as well. Think about what does your existing policy or rule say? How is this request different than the standard procedure or service? Do you need documentation? Which we'll kind of go into that documentation a little bit later in this. When and how does the policy get changed? But all of it does require some homework, and that is something that we can talk with you through. Now moving into assistance animals, which is considered a reasonable accommodation, but we have a poll here first that I will get launched. But the first question is and these are true and false, a person is limited to one assistance animal for disability-related needs, true or false. Two, you cannot charge a deposit or upfront cleaning fee for an assistance animal, true or false. I'll give people are really quick to the draw here, so I will give folks about 20 to 30 more seconds to answer these questions. Great. About 10 more seconds here. So if you are in a group, just get to a consensus and send in your answer. All right, I'm going to end the poll. So for the first one, a person is limited to one assistance animal for disability related needs. 78% of you said false, and you are correct. It is dependent on what a person needs. So if they need animal A for the ability to get out of bed for depression, and they need animal B because it's a animal that requires a lot of exercise, so it gets them outside, then that would be something that a documentation would need to outline. What is the disability related need for animal A and animal B? So there is no limit on assistance animals. Uh, the second one here, you cannot charge a deposit or upfront cleaning fee for an assistance animal. This is true. So 87% of you were correct. No upfront fees for assistance animals. However, if your standard procedure is to collect a security deposit and then assess for damages at the end of a lease, that can still stay true. And then you would assess for any damage that is done to the unit. If there was assistance animal in that unit, you can still do that. So thank you for participating in that. So going into what assistance animals are, so there was some guidance published in 2020, which is a very lengthy document, but it is very, very helpful when working through processing assistance animals. So this guidance outlines there are two types of assistance animals. So assistance animals is the umbrella term. The first section of that is service animals. So these are the trained animals. And the assessment actually begins with, is this animal a dog? Is this animal an individually trained service animal, generally a dog? That is the first question there. And these animals are the ones that are often allowed in public spaces under the ADA. The second one, HUD refers to as support animals. These are trained or untrained animals that do work, perform tasks, provide assistance, and/or therapeutic emotional support for individuals with disabilities. So we have service animals and support animals, but both are considered assistance animals. When processing assistance animals or getting a request, you may have to incorporate information that you already know about the disability or the disability-related needs. So you may already have some information about this individual and their disability, so you would have to utilize that information when assessing the request. This is pulled directly from the guidance. This is on page 9 through 11. If it is not a service dog, these are kind of the three questions you want to be asking yourself. Does this person have an observable disability, or does the housing provider have information to believe they are a person with a disability? The next one here, has the person requesting the accommodation provided information that supports that they are a person seeking the accommodation has a disability? And the 7 here, has the person requesting the accommodation provided information that supports that this animal does work, provides assistance, performs tasks, or therapeutic emotional support? Some more information here. So a dog, cat, small bird, or other domesticated animals that are traditionally kept in the home can be utilized as an assistance animal. However, if they are a unique animal, there needs to be a person would need to demonstrate a disability related need for that specific animal or that specific type of animal. So that would be reptiles, other than turtles, barnyard animals, monkeys, kangaroos, or other non-domesticated animals. You would just need additional information to say why this specific animal is needed for this person's disability. So it just requires a little bit more information from the person in the documentation just to say this specific animal is needed. As in the poll question, there are no fees, deposits allowed for an assistance animal. Additionally, pet rules do not apply to assistance animals, as well as limitations on breed or size. Uh, a housing provider may charge for damage if that is your usual practice at the end of the lease. A housing provider may refuse to a reasonable accommodation if the animal poses a direct threat and that cannot be eliminated or reduced to an acceptable level through actions the individual takes. So if the dog is lunging, or let's say it's a dog, or it's snipping at people, if it just requires training or a muzzle or things of that nature, that can be a conversation between you and the tenant to see, okay, what can be done to make sure that a tenant is maintaining control of the animal, because that is required and is outlined in the HUD guidance that a tenant has to maintain control of the animal. Again, it also outlines that the tenant has to be, just maintained and cared for, and that is on the tenant to do. However, there is a clause that says the tenant may have assistance with this if it is necessary. So that is something that may happen when a assistance animal is being requested. And we do have a sample assistance animal policy that does outline these things, and it can be provided to a tenant with an assistance animal to kind of outline that there are still responsibilities required by them and that they acknowledge them and you acknowledge them. It's separate from pet rules. This is a different policy. With having an assistance animal, as I've kind of mentioned before, it has to go through that good faith dialogue of the interactive process. A housing provider may not insist on specific types of evidence if the information provided meets the requirements of the guidance. Disclosure of details of a diagnosis, the severity of the disability, or medical records, or a medical examination cannot be required. Housing providers may not require a healthcare professional to use a specific form, including the HUD document, or provide notarized statements or make statements under penalty of perjury. You can recommend and you can show that this is kind of the recommendation provided, but you cannot require certain forms. You can provide. We have example letters, and you can provide our information to folks, and that kind of is theirs to take and to utilize. Additionally, other alternatives need to be provided. Again, we see often, these are kind of some issues that we see across the board, requiring those certain forms, charging fees, using subjective language, assuming a person's trying to avoid pet rules, requesting more information that is needed, and then asking a healthcare professional to testify in court. So we see those kind of issues that HUD specifically calls out you cannot do. If there is inadequate or no documentation, educate the requester, invite them to provide further information. You can provide our resources. You can refer them to us or our website, and you can make determinations on a case-by-case basis. Again, alternatives must be offered if the request is denied. Now moving on to reasonable modifications. Reasonable modifications are the change in structure to the premises or to a unit for a person to have full enjoyment of the premises. Some examples: a ramp to the entrance, grab bars in the shower, swapping out doorknobs for different lever handles, a different stove with different controls, and then, as mentioned in one of our examples, a flashing light for a phone or even a doorbell. And then Section 504 of the 1973 Rehabilitation Act calls out that if a housing provider receives federal financial assistance, and there are changes needed by a person with a disability, it is considered a reasonable accommodation, and the housing provider must provide them. Unless there is a undue financial or administrative burden to the program, or unless the housing provider can accommodate through other means. So it just changes again when Liz asked at the beginning if you have federal you receive federal financial assistance. This is important because it would change how you process reasonable modifications. The Rehabilitation Act includes federally assisted housing providers, and this is just a quote called out that thus a HUD-funded public housing agency or HUD-funded nonprofit developer is a recipient and must, subject to these 504 requirements. This is a case out of our case as a reasonable modification request. It was actually a senior center bus driver alerted us to this case. So this really just shows the partnerships that are really important when finding and educating folks on their rights. This was a 93-year-old program participant who used a lawn chair to go up and down her front steps. You can kind of see she has multiple lawn chairs to kind of provide that assistance to go up and down those steps. A handrail wasn't required by local code. However, it would have been beneficial to this resident. The basement stairs also lacked a railing, and she would tie the laundry basket around her waist with some rope and then drag it up the stairs. We were in the process of requesting a reasonable modification for her basement and her porch. But through working together with the family, the senior center, the bus driver, she did realize that she was ready to relocate to senior housing, and now she is living safely and independently. So these are some more questions on reasonable modifications and things you may be needing to be thinking of when processing them. Who will use the modification request? Is there any issues regarding code compliance? Do you need documentation? Do you need drawings and plans? Who pays for it? Again, how's your property funded is the next question. If it's private housing, the tenant pays, but if it's federally funded housing, then the housing provider pays. What happens when the tenant moves out? We do have that joint statement again linked there. However, it requires homework, and it's something that we can talk through with you. Some things to just think of and just be conscious of is really it's about communication, follow through. Impact on landscape and aesthetics is not a reason to deny a modification. And as a housing provider, you can require it to be built in a workmanlike manner and it be held up to code.
So there are a number of questions in the Q&A, which I do see. Our next section is going to be talking about processing requests after we take a 5-minute break. So I just want to say we see them. We'll go through the processing request section, which will be, I think, the last part of disability. We also have kind of a deep dive look at a case, and then we'll take those questions and get back to folks once we review that, because I think some of it will be helpful to hear to answer those questions. So if you would take about 5 minutes, and we'll reconvene at 5 after 10. Just a quick verbal cue to encourage you to head back to your seats and your screens if you haven't done so already. It's just about 5 after 10. I know that was quick, but we've got a good amount of information we want to finish together in our next hour.
And just a reminder, please place questions in the Q&A as we will miss the ones in the chat.
Thank you. So as I mentioned, we're going to kind of shift gears talking about a little bit more in detail on how to process requests for accommodations and modifications. And we'll do a deep dive look at one of the recent cases with some lessons that we can all take away from it. And so I know that we'll circle back to some of the questions that are already in the Q&A. But we wanted to cover this and then we'll quickly look at those. A housing provider is entitled to obtain information that's necessary to evaluate whether an accommodation or modification may be necessary due to a disability. So as Bree mentioned, with the assistance animal guidance, there's kind of 5 questions that you can talk through and evaluate. I think it's really important to look at what information you already may have on hand. The HUD guidance does encourage that, whether it's an assistance animal or any other type of request. You may be able to observe that the person has a disability, which then limits the need for any supportive documentation. You may be able to see that they are utilizing a service dog or using a walker or a rolling walker or rollator. You may be able to observe there's a disability. They may be on disability income. So the first question is to really kind of pause and ask ourselves what we already know. So that I think is starting to address some of the questions that I've seen already. You really want to evaluate carefully what information you want to request for supporting documentation because you can use the information that you already have and then decide how much more information you may need, if any at all. If somebody is utilizing a wheelchair most of the time, then we don't need a letter from their doctor, supporting the request to maybe put in a lower threshold or a ramp, things like that. If we can observe the disability and the need, we don't need documentation. And in fact, we encourage that housing providers generally never inquire about a disability, about the nature of it, the severity of it, unless they ask for an accommodation or modification. So if the disability isn't obvious, if the disability related need isn't obvious, what kind of information can we request in support of an accommodation or modification? Generally, you're looking to answer 2 questions. Is this a person with a disability as defined by law? And do they have a substantiated disability related need? What is the connection between the disability and what they're asking for? What's that need tied to that disability? So here we have a couple of questions to kind of start applying our thoughts on using our knowledge here. This is going to take a little bit of time. We have 3 different scenarios that we want you to review and then choose whether you think you need information on disability related need, on both, or on neither. So we'll leave this up for a few minutes because there's 3 different scenarios we want you to look at and evaluate of, what supporting documentation would this situation require, if any. And we did include an option for I'm not sure, which is always a good option. As Bree mentioned, there's opportunities for us to say, I'm going to have to look into this. And so we encourage you to be honest about that. And quite often these requests do require a little bit of digging, a little bit of research, looking at HUD guidance, looking at the Fair Housing website. So we'll give maybe another minute here. And we will review these together. So if you don't get through it, that's okay. Okay, in the interest of time, I'm going to end the poll and share our results here. So our first one, we have a senior applicant who uses a motorized scooter, requesting permission to use different hinges on her front door to increase the space to enter her apartment. This is a situation where you would likely know that there is a scooter. And so those of you who said she doesn't need to provide information on either the disability or the disability related need, I would agree. I think the presence of the scooter and the hinges kind of make sense, that she needs the space to allow for the scooter. And that's something that's more observable and likely to be known to you already. Our second one here, our middle question, a longtime senior resident asking for grab bars at his front door and bathroom due to his vertigo worsening. This one, you all kind of had different opinions, and I can certainly understand why. Vertigo is likely something that you aren't able to observe and you may not know about. And if that's the case, you could request that information. I do think it makes sense once we know that this is a person who is dealing with vertigo, that, the disability related need is pretty clear, but you may not know that there is a presence of a disability there. So that one I would really kind of do an evaluation of what do we already know. It does say that he's a longtime resident, so people may already know about this or have information, but that would be one where I would pause and assess that. Our last one is a resident who's new asking for a rental due date to be after the first and not to have to pay late fees every month. This is one of the examples we gave early on. And 40% of you said they don't need to provide either information on the disability or disability related need, which I would agree with. They're on disability income, so the government has assessed that they are a person with a disability, and we know when the check arrives. And so we don't need information on the need because we know that they are on disability income and we know when it arrives and they can show that. So great job on that. Always helpful to kind of pause and think through this. So just a couple more notes on the process, and then we'll look at the good questions coming in. These are requests that can be made anytime. As I mentioned, you could be a longtime resident or a new resident, like in our examples. They can say it verbally, they can submit it in writing. You need to accept the requests and document the request has been made and begin addressing it, regardless of how they are made. So Bree mentioned way early on, that somebody may not say, I'm a person with a disability and I need an accommodation. They may say, my vertigo is getting worse and I need grab bars. And that's the equivalent of making that same request. So listening for those and acknowledging them, documenting them, and getting moving on them is really critical. These are requests that typically need to be evaluated and decided on a case-by-case basis. Some can become fairly standard, especially in senior housing, so you may have kind of a well-oiled process in place, but generally you always want to look at the unique facts. Modifications must be allowed in Michigan for the most part, and of course the federal funding at a property increases the obligation to provide those and cover the costs as deemed reasonable. No fees or deposits should ever be charged. You really do not want to accumulate anything related to the presence of a disability in terms of financial costs. How do we assess reasonableness? These are our kind of parameters that we can look at. Could you prove an undue financial and administrative burden on the housing provider? Is that quotes from several developers? What homework did you do to establish this burden? What could you show if you were ever challenged or asked about how you came to this decision? The other option is if it's a request that is simply outside of your day-to-day business, it would alter in a fundamental way the nature of what you do or your housing providing operations. So it's outside of your scope. And again, you'd want to have information to prove that. And then if you do show that something is unreasonable, you have to engage in further conversation and offer some alternatives that would effectively meet the needs of people, up to releasing them from the lease if need be, because the changes can't be made to make their housing work for them. So I think, Bree, if you could help me go through the questions, I think we'll do that real quick before we look at the case because people have been waiting patiently. We and some of these we may want to follow up on with individual conversation because I know some of these are challenging. Like our first one here is we have someone who is knocking on doors in the middle of the night, middle of the night, and we really can't advise whether or not you could evict that person without a lot more information. But we really encourage you to do as much as possible. If mental health is working with this person right now, I think, efforts are still underway to address the concerns, and that would need to be taken into consideration that the process is still ongoing. I know it's challenging when other neighbors are being impacted, but you really want to do absolutely everything that you can to prove that you did everything that you absolutely could to accommodate this person. So I know that's not the yes, no that you're looking for, but again, that's not something we could do. We could point you to different parts of the guidance if you wanted to share more details with us. Um, Another question on hopefully that's a 62 plus senior living complex because it can't be 60 plus. Management asking for proper documentation as to not being able to live independently. That's again something that depends on what you already know. You may have been going through accommodation and modification requests with them, and you may know this isn't just working out. We are not able to make the changes because it would violate code or whatever. It's too expensive, whatever the case may be. So you need to take those unique factors into account before asking for any documentation. You may not need it. So the answer for that one is it depends. I know that's not a popular answer, but it's one we always kind of have to fall back on with accommodations because it depends on the unique facts. Suggestions for a tenant with an ESA dog that chronically drops the leash handle when walking the dog. So, we do need a little more information about that. Is that something that was a part of their original request that sometimes the animal is not restrained? Is there a leash law in effect where the housing is located? Would they be violating law? What's in your assistance animal policy? What's the harm of the animal being unrestrained? Is it threatening people? Is it running around? So a little more information there would be really beneficial as to what would make this unreasonable. And Bree, feel free to chime in if I'm missing any points on these as well. Regarding specific forms, I think absolutely if you have a letter from a healthcare professional that answers the questions that you're allowed to ask, asking them to complete an additional verification form would be seen as burdensome. And HUD has charged cases where people have done that. They don't deviate from the policy. And sometimes I can think of one case where a doctor wrote probably one of the best accommodation letters I've ever seen on behalf of a child with severe asthma. The doctor didn't fill out the form because he had already done an incredible job with the documentation. Unfortunately, the housing provider insisted on the form, and HUD said you can't do that. So that case is underway. So I'd encourage you, you can have the form, you can offer it, but you cannot require it. And especially in this situation, if you've got a great letter, you don't need it. You have the answers to your questions that you're allowed to ask. A question about a psychiatric service animal, I think we would need more information about that. I'm sure there are service animals that do provide assistance for people. Um, Go ahead, Bree.
I was just gonna say, I think the focus isn't on the what the animal is called. If the
Mhm.
documentation outlines that they are a person with a disability and they have a disability related need for the animal, then it answers those questions. I don't know if the semantics would play into it. If it's just saying they need this psychiatric service animal, you can invite them to provide more information to say, okay, what again, that nexus between the disability and the disability related need. So I think we would need more information in what is being asked by this, but I think it comes down to what is the disability, if they're shown a disability and a disability related need for the animal.
Yeah, thank you. And whether it's a service animal or not depends on is it a trained dog or not. So encourage you to check out the HUD guidance on assistance animals because it kind of splits those two definitions of animals in a nice Q&A type way. Receiving project-based Section 8 vouchers at a property, would we still be responsible for reasonable accommodations or would this be a shared cost? I think we would want to evaluate that on a case-by-case basis. What is the request? What is the impact? And it depends on what they're requesting as to whether or not that would be something that is shared. I think generally the responsibility would fall on the housing provider in this situation, but I think we need a little bit more information on what the request is. Is it common areas? Is it for their individual use? That sort of thing. So it may not be shared. If someone wants to adjust their due date to match their disability payment date, can we request some sort of documentation to show their payment date? Yeah, if you don't have that as part of the request, you do need to know when the payment would be made in order to verify and make sure that the accommodation is appropriate. So that would make sense to me. Sorry, these are kind of hopping around on me.
The next
Ooh,
one we have here is if someone, oh, we just did that one. Who is liable if a service animal attacks another tenant, owner of the dog, or the housing provider who was required to allow a service animal?
That's a question I would speak with an attorney about. We can't provide any guidance on that type of liability. It also depends, a lot of factors depend on that, we need more information on. The what HUD guidance does say you cannot, kind of require liability insurance or, any of those fees or additional things would be a burden on someone making a request, whether it's for an assistance animal or other type of change. So I would recommend looking at the HUD guidance, but you would need to speak to an attorney about liability. Um, I'm not sure what that question is there about assistance animals. Following up, I think on the psychiatric service dog, it's common language. Um, Yeah, so Ashley, your question, we encourage that you give people the same guidance that you're looking at. We tell people all the time, educate the tenant, educate the requester, have them call their local fair housing center so that they understand. There's a lot of really bad and inaccurate information available on the internet by Googling. And so, yes, people often misunderstand and use the wrong language. And we're happy to do that education, but we encourage you to do that education as well. We have a lot of materials to help people understand fair housing laws and assistance animals and service animals as well. A wheelchair user asking about a barrier-free unit and assessing damage to the doorways. I mean, that is very fact specific. I think we'd need a lot more information in order to make that assessment. You know, if it's above normal wear and tear, there might be an opportunity there to assess for those damages, but we'd probably need a lot more detail to answer that question accurately. So, okay, keep an eye on the clock. I am going to move forward. Bree is typing some answers as well. We wanted to do a quick deep dive into a Michigan-based case. This was an investigation into a very large housing provider that did manage senior living communities or does manage them. And we found 5 areas that we thought were beneficial to kind of take a look at and learn from. So denying accommodation requests that were reasonable, charging fees, as we've mentioned, is problematic, stating that a person applying for independent living would need to have a medical assessment by their doctor and the on-site nurse before being considered, regardless of whether they were applying for independent living or assisted living. That's been a big trend in the last 5 years where independent living housing providers are doing these assessments that are not allowed under fair housing, making statements that are considered discriminatory on the basis of disability, and publishing ads that were not appropriate in terms of representing the local demographics and being inclusive of models of color. and people that were other than white. So 5 issues identified. We'll take a look at these very quickly. Accommodation requests that are not financial and administrative burdens and that do not alter the nature of the provider's operations, those are reasonable. We've talked a lot about these. They have to be assessed on a case-by-case basis. It takes homework. What are the costs? Who would have to pay the costs? What laws apply? What alternatives are there to offer if something is found to be unreasonable? So we really encourage you to use a lot of caution if you find that you're in a position where you're considering denying an accommodation request or a modification. You want to look at these 2 standards and make sure you would have something to show the work that you did and how you came to these conclusions so that you could respond should you be challenged by a civil rights investigation. Charging extra fees, you cannot do that. No extra fees, no deposits as a condition of receiving a reasonable accommodation. So that's a very straightforward violation from HUD guidance. Asking for those assessments, this is clearly prohibited by fair housing law. If there is no medical services included in the housing, you cannot do any sort of health-based or medical assessment. Just full stop. They made statements that are considered discriminatory on the basis of disability. During the housing investigations, someone was told you might not be a good fit when they were talking about their health and inquiring about kind of the spectrum of housing available. So having that sort of conversation or discouraging someone on the basis of a protected class from pursuing the housing is a violation. And then the published ad campaign, disproportionately low models of color and people other than white, which was not representative of the communities where the housing was located. And in fact, 100% of the human models they used on the website and advertising were white. And that is not at all the local demographic reality. This is often an issue that we see in senior housing because they are trying to communicate a sense of community and warmth and a place that people would want to be. So they often use photos of human models, as we call it. And so if you are choosing to use pictures of people, you do need to be inclusive across the list of protected classes and make sure, especially if you're located in a diverse community, that you're reflecting that diversity. We do offer to review ad language and campaigns, so feel free to reach out to us or your local fair housing center to see if they would do that as well. So this obviously was a case. It was filed at the state level. Throughout the investigation and the mediation process, this company decided that they would stop those assessments, physical and mental assessments for those applying for independent living. At that point, as an independent living provider, all they were offering was housing. There were no health-based services, so they cannot collect health-related information. So they made that agreement, which is now in line with fair housing. They developed a policy for responding to reasonable accommodation requests. We do have some sample language around that if you're interested. They trained their staff on the new policy, and they reviewed their marketing and website materials and updated them significantly to be more inclusive of people with disabilities and people of different races and national origins. And they also settled for financial damages in the amount of $25,000. So a lot of work to kind of revamp certain things, but they did the work and made these changes and opened up hundreds of units now to older adults across the state, which is really exciting. We always want to see those discriminatory barriers removed. I'm sure there's questions coming in. I'm going to keep going, I think, and then we'll circle back. There's a couple more sections we want to make sure we're spending some time on. So for advertising, we have a quick poll. Sorry, my Zoom bar is being very picky today. Slowing me down. Come on, Zoom. Just a quick poll here on advertising, thinking about language and best practices. Which of the following terms are generally acceptable to use in advertising a senior property? So again, this is really just to kind of help us think through what would we want to put out there? How would we advertise? What phrases you feel comfortable with? What phrases might be red flags? What would we maybe not recommend? And again, these are all anonymous. I'm going to allow about 20 more seconds. Moving quick here, I know, but we have a couple of good sections we want to make sure to cover. One of the challenges about advertising is words can be very subjective, and the full final message really does make a difference. So I will say it can be very hard to kind of just pick and choose from words. It depends on how these words can be used, but hopefully this will be a good quick look at what we want to see and what we would want to avoid. So I'm going to stop and share. 84% of you said 62 and older, 49% said 55 or better. Those are the legal age restrictions in compliance with HOPA, so those can be published. We really encourage that no other age limit in Michigan be utilized because it would be challenged under state laws for age protections. Independent living, if it means that it is independent living, you could use that, but if you're talking about the people, independent, I would use caution there. If you're talking about independent living, that's okay. But when we're looking for independent residents or residents who can care for themselves, residents who are active or stable, those to me are red flags. Same thing with mature or mobile. That is also potentially discriminatory on the basis of disability. And so we would discourage those. And we certainly would not allow ads. Even if you are exempt, because of how fair housing laws are written, you cannot advertise no kids. You simply can state that you're housing for older adults and the age restrictions that you meet under HOPA. You do not ever want to advertise anything like a negative like that either. So, okay, we'll get back into this a little bit more, but thank you for playing along. We do also want to encourage you to check out guidance that HUD released last year. It focuses on advertising online and also tenant screening processes that utilize technology, artificial intelligence, online platforms, algorithms, all of that. These were included in your handouts on the email that you should have received as well. But some really good information in there. On the advertising side of things, it's very broad. Anything related to an ad for sale and rental of housing, you really want to scrutinize next to your list of protected classes. You want to use caution in talking about any groups of people. It's really best to focus on describing your property, describing your programs, and not the perfect tenant, not the perfect resident, because it's unlawful to have any sort of published ad, statement, or notice. This includes verbal communications. How we communicate now is so different. There's a lot of emailing, texting, less face-to-face, but all of that is subject to fair housing. So you really want to be careful. Any flyers, brochures, legal documents, deeds, signs, banners, promotions, any document that's used, any communication that's used, including oral notices, verbal notices, needs to be in compliance with fair housing. So again, you cannot advertise in a discriminatory way. You can state 55 or 62 and older, but that is it in terms of advertising for senior housing. It's promotional materials, it's newspaper and internet ads, it's verbal statements. So again, very broad. So best to use caution and make sure anyone who is representing the housing opportunity is familiar and knows to focus on the housing, focus on the program, not the people. There's very limited exceptions for program-based housing. For example, there's housing allowed to have homeless preferences under HUD guidance, but very limited exceptions. If you have questions, let us know. As I mentioned, we do see a lot of human models, and this is something that needs to be very carefully scrutinized and evaluated to be a lot more inclusive based on race, skin color, national origin, disability, etc. So it takes work to be inclusive. If you're going to use human models, you really need to make sure you're being inclusive across all of the protections. The least riskiest or 0% risk is no human models, no indication of any preference, limit, or discrimination. You're focusing on rooms, units, features, amenities, ambiance, services. The closer you get to 100% of depicting everyone as white or having only staff represented who are Black, Latino, or Asian, that selective representation, that is problematic. Or as I mentioned with that last case, everyone depicted was white. That increases risk of not being in compliance with fair housing advertising best practice standards. So there are some limited examples from HUD that do allow for some guidance or kind of better understanding. People often say, can I include a phrase about a walk up or a walk in or a walk to a bus stop? You do want to be sensitive, but HUD has said, you can use those types of terms, but we can also offer more up-to-date references. Maybe you want to say two blocks to the bus stop or give the distance. You certainly don't want to include any information like saying no ramps or not wheelchair accessible, things like that. It's kind of an adverse statement and it's intended to exclude people, and it would be a fair housing violation. You can describe conduct required of residents, for example, non-smoking or sober. That does not violate the Fair Housing Act. And conversely, you can highlight accessible features. If there is a ramp, that is something that you could state. If there's grab bars in the bathroom, you can state that. HUD has said that, but you don't ever want to do the opposite, kind of the negative. If you might not want to believe that an ad has been posted that says no wheelchairs allowed, but there is a case in Michigan being pursued just on that exactly. Not only was there information posted about it, but staff also said it to people. You cannot say that people must be able to live independently. People can bring in their own services, caregivers, live-in aides, things like that. Housing available for single residents would be problematic, and as we mentioned, active seniors only would be problematic as well. So kind of revisiting some of those problematic words or words that I think are confusing. I mean, traditional housing, what does that even mean? So again, really encourage you to be very cautious with your messaging and any information that you put out. Some best practices: describe the property, not the people. Very simple. Make your advertising inclusive, not exclusive. Be sensitive and use caution when describing property. You know, people say, oh, you can't say things like great view, and that's not true. But you can describe what the view is. Tell me why it's great. I think being a little bit more specific is actually helpful. You can describe any programs or services, just not who they're perfect for or ideal for. And don't publish limits. Disabled older adults can determine what property is appropriate for themselves. That's often something that people try to do as a service, and really they should know what their alternatives are and choose for themselves. If you have any doubts, don't publish or post any advertisements or communications without making changes or consulting fair housing guidance. You do want to display the equal housing opportunity poster. We do have that in English and Spanish. And on the right here, you want to use the equal housing opportunity logo. It's something that HUD looks for and indeed requires with anybody who has federal financial assistance, but we recommend it across the board. Very quickly on applications, you can ask for people to substantiate different sources of income to kind of verify they do have the income. You can ask for references. If you are screening for criminal background, you can ask for that information. And if it's senior housing, you can ask for age and verification of age. So those are allowable questions, but you cannot ask, with some limited exceptions, any of these questions about daily activities, getting in and out of bed, using the toilet, taking medication, if they're under the care of a doctor, if they're being treated for mental illness, details about the disability, the severity and the nature of it. That is all problematic. In limited circumstances, if you do provide both housing and supportive services, you can ask for limited information about disability status, but you do not want to go too far. Check out question 16 on the joint statement from HUD and the DOJ. And we really encourage at the application stage that housing providers obtain medical or disability info after first determining preliminarily whether or not the person would qualify as a resident, kind of splitting that. This should also be applied for any information being sought about religious affiliation, if you, to be prepared to contact appropriate clergy regarding health-related events. Request this information after the individual has been accepted and not on the application unless you're an exempt provider, which would be a very small group. So sample questions after they're accepted. When is their wedding date? When do they celebrate their anniversary? What are their daily needs, hobbies, interests, religious affiliation, et cetera? Separate that from the application side of things. Be very careful to only focus on information that's relevant and to objectively determining whether or not they qualify for the housing opportunity. Make sure you're not asking unlawful questions. We've had changes in protected classes, so it's a good time to do the review of any questions. I know somebody mentioned I was coming across forms in the office and kind of digging out, that's great. We do want to see that, keeping up to date, looking at what we're doing, what are our daily practices to make sure we're not asking for unlawful information or information we're not even using anymore. Okay, so I'm going to turn it over to Bree. We've got about 20 minutes left, so we went a little bit long. I'll take a look at some of the questions and see what I can do, but we're going to talk about criminal records and then circle back to some of the resources.
Thanks, Liz. So starting off, we do have a poll here. Let me get that launched really quick. But while thinking about it, this is a true or false question. A lifetime look back period for any felony convictions is an acceptable policy for 62 and older senior housing properties. True or false? I'm going to be quick on this one just because we only have 20 minutes left. So I'll give about 20 seconds here for folks to answer it. But you guys are really quick to it today. So, eight. It's starting to slow down here. I'm going to end that poll. I know some of you were probably putting in your responses, and I apologize. So, a lifetime look back period for any felony convictions is an acceptable policy for 62 and older. True or false? That 63% of you are correct. That is false. And we'll kind of dive into why that is not acceptable here in just a second. Liz, do you want to go to the next slide, please? In the 2016 guidance, it addresses the private housing market, but essentially it really calls out if any criminal conduct indicates a risk to the resident safety and or property. And it has really that your policy should take into account the nature and severity, the amount of time that has passed, which going back to our last poll, a lifetime look back period would be unreasonable. And then also your policy should take into consideration an individualized assessment. What kind of actions, what is the criminal background, conduct that the person had? Is it, again, is it a risk to people or property? Has it been, 30 years and nothing else has happened? Really taking those things into consideration. However, you can exclude illegal drug manufacturing or distribution charges. Additionally, housing providers should not use arrest records, not resulting in convictions, and blanket bans or prohibitions should not be utilized. In 2022, additional guidance was put out, and it does note that criminal history is not a good indicator of housing success, and that private housing providers should not consider using criminal history to screen tenants for housing. So that was a recommendation that was put out by HUD in 2022. The HUD guidance calls out that it really should look at you really should consider other options of like why someone could be fit to live there, and then not consider the criminal history. But you should check for state or local laws that may limit the ability to run criminal backgrounds, avoid third-party screening companies that used biased algorithms, have written criminal background policies that are available to all applicants, and again, delay that criminal history after you've verified if this person is qualified to rent or lease your unit. And then treat all comparable, comparable criminal histories similarly. Before denying an applicant or evicting a resident, provide them the criminal record and give them the opportunity to correct any wrong information or explain the circumstances. Only evict a criminal for criminal activity as a last resort and after an individualized assessment. Never evict a person or family because they are victims of a crime. Do not ban a tenant's invited guest from visiting based on the guest's criminal involvement. These are clearly called out in the HUD guidance. Sorry. And then again, we cover this a lot. Just document everything. Document the screening and the circumstances considered and the decisions that were made. Some more best practices, as I mentioned, consider the nature, the severity, the recency, ensure the policy can be justified with any reliable evidence to show that it actually protects residents and the property. Avoid automatic denials and blanket bans, as our poll called out, just the ban of, the lifelong look back period. Consider the amount of time that has passed. And as I mentioned, provide that individualized assessment to really look at the circumstances and the information that is provided, either in whatever you get back from your what you've ran or what the tenant can tell you. Has this person maintained a good tenant history since the conviction? Do they have evidence of rehabilitation efforts? And there should be some consideration for any request for reasonable accommodations on the basis of disability if the criminal conduct was committed because of a disability, and that person is now in recovery. They are seeking treatment, and that could not be replicated again. Then a person could request a reasonable accommodation to not have that criminal history considered. This is a case that was a Fair Housing Center West Michigan case. A Black man in his 70s contacted us because he was denied because of his criminal history. We found that the policy was unclear and inconsistent, and according to the policy, he did not have any convictions that would justify a denial. There were other concerns within the policy. Our center helped him file a HUD complaint alleging policy discriminated based on race as it had a disparate impact on people of color. Unfortunately, during this time, he experienced a prolonged episode of homelessness related in part to the provider's denial. He was able to go forward with can you go to the next slide, please? A settlement that included $1,000 towards moving expenses, guaranteed immediate housing at the provider's location of his choice, and a credit towards 8 months of rent and security deposit. He moved in last fall and does not have to pay rent until next month, actually. So it's a really great outcome for him. There is additional guidance that was put out in 2015 for public housing authorities, and it does outline these four things that housing authorities must deny admission to their property if anyone has been convicted of manufacturing methamphetamine on federally assisted property, a lifetime registration for a sex offense, if they're a current user of illegal drugs, abusers of alcohol, or patterns of interfering with health, safety, and the peaceful enjoyment of the space. And the last one, anyone who within the last 3 years hasn't been evicted from federal housing for drug-related crimes, unless there's been rehabilitation or the circumstances no longer exist. And then the next list here is public housing authorities may consider these when denying, but they're not required to. But drug-related criminal activity, violent criminal activity, and any other criminal activity that would affect the health, safety, and right to a peaceful enjoyment of the premises by other residents. So these are not required, but can be considered. We've heard this a lot that some housing authorities have one strike policies because they're required to. Housing authorities are not required to have one strike policies. There should be discretion to deny, evict, or terminate based on certain types of criminal history, based on like the seriousness of the offending act, the effect on the entire household. Any steps taken by the leaseholder to prevent any criminal activity, and participating in any real rehabilitation programs. So really, it's a case-by-case basis. Consider the facts of the information you're given and kind of go from there. There is an FAQs on excluding arrest records. Consider available evidence of criminal activity. Review police reports, witness statements. Before denying admission, notify the applicant and provide the records that you were given, as well as allowing them to dispute or request an informal review.
Okay, we have a couple questions. We're going to switch topics, so I just wanted to circle back. I'm trying to type as fast as I can. Hopefully, what I'm writing makes sense to folks. But we had a question about what about people who are unlawfully convicted, like a lot of men of color? That is a very large question that we really, I think a lot of this guidance, these cases that have been brought, that's something that it's really trying to address. Race is the underlying protected class that a lot of this guidance and case law is being built on. Unlawfully convicted, there's a lot of efforts to try to help people address that in terms of expungement. There's also a lot of the HUD requirements and cases are really requiring people to look at accurate information, actual convictions. So it's something that is really being addressed and has significantly been addressed beginning in 2016 and kind of moving onward. It's very hard to prove unlawful convictions. And that's where I think the individualized assessment can really make a big difference for somebody who has the opportunity to tell their story, provide additional information about the efforts that they've undertaken to address the criminal background, things like that.
Yeah, and
Um,
I think part of that is the good thing is, if they've had a good tenancy in other places, that's a good indicator that there is no concerns for you to take them on as a tenant. If they can show that they've lived at this last place for 5 years, there's been no issues, they've paid rent on time, then that would be a good indicator that this person is really not a concern.
Yeah, and I would really encourage you to check out the 2024 guidance that is one of the handouts on tenant screening. It talks about a lot of the kind of things that have really become a barrier for people, including criminal background, but eviction records. We know that that can have a racially disparate impact on who has those types of eviction records and histories. Criminal background is another one, and they're also looking at credit scores. So I encourage you to check that document out. It's really interesting. And then a question about I was told current users of substances would qualify if they were undergoing treatment for addiction because addiction is considered a disability. Am I misunderstanding this at all? So if somebody is no longer using and in recovery, they are considered a person with a disability. Current use, as the way it is written now, disability protections are likely not going to apply.
I
But
also
again,
think,
case by case evaluation would be important there.
yeah, because I do know there are some treatment options that do um,
Allow. Mhm.
allow for current use of certain substances. So that would be, again, that interactive process of working with that tenant. And maybe it would mean documentation. It would really, there would have to be other facts,
Yeah.
provided to assess.
Yeah, the definition is really from like late 80s and guidance is from mid 90s. And so it hasn't kind of kept up with that kind of modern understanding of how to help people really meaningfully achieve recovery. So we're kind of stuck with what the guidance says, but that's where that individualized assessment is really important. Um, how would you be able to verify if you suspect they are a current drug user? That is beyond our realm of expertise, unfortunately. I'm not somebody who could answer that. I encourage anyone else on the call if they have insight to share. Um, if it's part of an accommodations process, then that's something that you can request information on. If it's not, I don't have any guidance for you. And then very quickly, independent living developments, do they have any legal obligations if a resident no longer appears to be able to safely live independently? Outside of fair housing, fair housing would say it's really up to the individual to bring in the services. You can offer to connect them with services. We have some phenomenal county senior millages, for example, in Muskegon and Kent County. Every county has an area agency on aging. That's another tremendous network of resources. You may be required to report if you have a social work degree. So a little bit outside our area of expertise, and that does take a little bit more homework. I certainly understand a lot of housing providers are concerned for their residents, but a lot of people can't afford the next level of care. So it's kind of striking that balance. And I would encourage you to reach out to a fair housing center or a disability advocates network for more information on that. How can I address tenants having issues with people who have prior convictions living in the same building? You point to the law. This is HUD guidance requires, the policies to be more specific, to focus on, recent criminal activity. So you can point to the HUD guidance and the requirements that are in place to educate them to say, you're not allowed to discriminate, and hopefully that would help. Yeah, good questions. So I know we've got one more section, so I'm going to get back on track. And thanks for letting me jump in there, Bree. We had some really good questions this morning.
Yeah, so moving on to sexual orientation, gender identity, and expression. Michigan's Elliott Larson Civil Rights Act prohibits discrimination based on sexual orientation, gender identity, or expression, or otherwise known as SOGI, as well as marital status. HUD's equal access also final rule also prohibits discrimination for HUD-funded programs based on SOGI protections as well as marital status and the composition of family, which they define as any group that presents together for assistance, identifies themselves as a family, is considered a family, and must be served together. The equal access rule applies to all HUD housing programs, so they are listed there. Some examples here, a property manager who oversees a senior community operated with HUD funding refuses to rent to an apartment to a prospective senior tenant who is transgender. So that would be a violation. Now also under Elliott Larson Civil Rights Act as well. A senior who is gay currently uses a voucher to pay his rent, contacts the property owner to request to add his male partner who is the same age and income eligible to the lease so they could live together. The owner asks, "Are you gay?" and denies the request when the tenant confirms that he is gay. This would also be protected under Michigan Civil Rights Act.
Mhm.
This information and this data was provided from SAGE, just kind of showing the connection between senior and older adults and SOGI protections, and just that using their language, LGBT older adults have no children to help care for them, 9 out of 10, compared to those 2 out of 10 of heterosexual older adults. So just considering this data when kind of considering your populations you serve that may be LGBTQ. Some of the things that LGBTQ plus older adults have experienced when navigating access to senior housing is often when they are going into senior housing, it's considered a second closet or recloseting because they don't want to be out and they don't feel comfortable being out in those spaces. They may ask friends not to visit due to fear of being discriminated by staff and residents. They may rely on families of choice who do not have the same legal rights. In the past, some have posed as siblings to live together or turn to adoption to ensure that they have rights to live in the same spaces and to kind of hide that part of themselves. We have seen that they experience physical and verbal harassment and refusal to use their preferred names or pronouns in senior housing. So these are things just to be thinking of when you are serving your tenants. LGBTQ plus older adults have had they did a test where it showed that nearly half the tests revealed that heterosexual seniors were treated more favorably in comparison to LGBTQ plus seniors in terms of all the things, housing availability, pricing, incentives, application requirements. So just a complete difference in treatment in nearly half the tests that SAGE did. And they also found that 50% of senior LGBTQ plus people living in a long-term care facility said they were not comfortable being out about their orientation. So really, just a thing to take from this is make sure you're creating an inclusive environment, a welcoming environment, so that these folks don't feel like they have to be to not be who they are,
Mhm.
and being treated differently as well. Michigan did a similar study and found the very similar things. Fewer units were offered, higher rental prices. They were told of a mandatory community fee of 1 month's rent, did not inquire or offer veterans discounts, even though they may have been. They did not offer 2-bedroom at a 1-bedroom cost while waiting for a 1-bedroom. And proof of income was only required by an LGBTQ plus tester. So again, that difference of treatment was just found. Best practices ensure that your non-discrimination policy includes sexual orientation, gender identity, and expression. Post versions of the policy written in plain language in various open areas. Train your staff on LGBTQ plus cultural competency. They should include appropriate terminology, history, and the cultures. Demonstrate dignity and respect by asking for their preferred gender pronouns, and demonstrate, just the competency and sensitivity to LGBTQ plus needs, and include representation in media and advertising. Kind of going back to that human models, you have to show all different groups of the people that you may be serving.
Just on the nose here, we have some resources. This is a listing of everything that you got, but highlighting there's a link to a report on senior housing that you might want to check out. We put it out about 10 years ago. We're hoping to update it with some grant funds, but you have tons of resources to refer back to. And of course, our website is a great resource. We have a searchable archive. You're always welcome to email us and ask for information specifically that you're looking for. Our contact information is up here.